consult. We're now faced with times where the way economies are growing, we also have to look as to how not fall in the trap of disputes, which is a speed breaker for business and ease of doing business. Welcome to the second session of the series of webinars. Our take from the last session on the path of mediation carved its road to the present session of resolving MSME and consumer disputes through online mediation. Our host WebNyai has revolutionized dispute resolution for us, and we have with us today Ms. Veena Ralli, Senior Mediator, Secretary, Samadhan, Honorable High Court of Delhi, Mr. Somesh Arora, Advocate and founder of Legal Alley and Sapphire and Sage, and also Mr. AJ Jawad, a mediation trainer and advocate with us to continue the legacy of resolving disputes through online mediation. When our parents or elders say no, it means a stern no over and above the decree of a court. But can a mediation settlement have the same binding effect on the parties? I request Ms. Veena Ralli to enlighten us on this aspect. Welcome, ma'am. We are all eyes and ears to your valuable insights on the binding value of a mediation settlement vis-a-vis a decree bearing the seal of a court. Over to you, ma'am.
Thank you, Palak. Thank you for giving me this opportunity to share this panel with Somesh ji, Jawad ji, and thanks a lot, Vimosh ji, Subroto. You know, mediation is not new at present because we started mediation in the year 2005-2006 due to amendment in the Code of Civil Procedure, which was brought in existence in 2002. And today, we have reached at a stage where we are having webinars on mediation. We started our journey initially when people confused mediation with meditation. That was the beginning. And look at the position today. Today we are having many webinars. People like you also want to know what mediation is and where can it take us. You know, since the amendment in 2002 in section 89, there have been many centers have been set up for mediation, for court annexed mediation. This section 89 provides that wherever the court feels that there are elements of settlement, the matter should be referred for ADRs, alternative dispute redressal forums, and that is arbitration, conciliation, mediation, judicial settlement, and Lok Adalat. Arbitration is governed by Arbitration and Conciliation Act. We all know about that. To be very honest, even conciliation is governed by Part 3 of the Arbitration and Conciliation Act. Now, so far as judicial settlements are concerned, the judges are recommending those settlements. Judges are proposing the terms of the settlement. And so far as Lok Adalat is concerned, we all know that it is governed by the Legal Services Authorities Act. Now, when any matter is referred from court for the purposes of mediation to any court annexed mediation center, and if the matter gets resolved by a trained mediator on the panel of that court annexed mediation center, the settlement is sent back to court. The court passes an order or judgment or decree in terms of the settlement agreement, or it becomes a self-written settlement agreement of the parties, the decree of the court, and parties follow it. Now, question arises, what is the status of the conciliated agreement? That conciliated agreement is also, if you see all the provisions starting from section 62 to section 74 of the Arbitration and Conciliation Act, it is the settlement agreement has got the effect of an award, and award is a decree in itself. Now, today we have reached a stage where last year in September 2019, even mediation has been approved recognized at international level, and convention has been signed even by India. Now, question arises, what is the status of private mediation today? This is what is bothering everybody, and everybody is keen because people can see the benefits of mediation and do not want to go to the rigmarole of litigation for arriving at solutions. There are confusions. What is the status of this mediated agreement between the parties? Though in Delhi High Court, this confusion was set right long back in the year 2009 itself, in the judgment that is Ravi Agarwal versus Anil Jagota, 2009 SCC Online Delhi 1475, where Justice Sanjay Kishan Kaul, who is now presently Judge Supreme Court of India, he said that when party approaches any third neutral person for resolution of disputes as conciliator, then the result of that conciliation proceeding is the conciliated agreement, which has got the effect of an award under the act itself. But if it is merely an agreement between the two people, it says legislature in its wisdom has not considered it appropriate to provide for a mediated settlement privately arrived at to be enforced as a decree, beholds part 3 of the said act. So that settlement is an only merely an agreement between the parties, and so far, though we are looking for legislation on mediation and we are expecting something very soon, and maybe something important is some important value is added to such type of mediated agreements. I hope I am clear, Palak.
Yes, ma'am, absolutely. And I would also like to know that in the absence of any legislation, as you rightly mentioned, how have courts dealt with mediation for a matrimonial dispute?
You know, mediation works in all type of relationships, in human relationships, contractual relationships, commercial relationships, company relationships. And human relationships are very valuable. We all can understand that. In matrimonial relationships, discords occur because of many reasons. Let us not get into those details right now because it's a. But conflicts do occur in those situations where two different people coming from two different backgrounds, they start living together under one roof. Now, in that situation, when conflict arises and people are not shown the path what to do, people do come forward to this mediation at present to see that they get results today. Because in litigation, when one party approaches court, the party approaches with bundle of allegation. The opponent also comes forward with another bundle of allegation. And now the major issue which bothers the party is to set the court that I am right or the other person is wrong. That is the energy, the whole energy, time and money is used to prove oneself right. Whereas in mediation, parties can resolve their issues today when they need it. Particularly, you can say that particularly in young couples, when they want that, okay, if this marriage is not working, let us put an end to this marriage. And for that, mediation works. Now, in that situation, even you can say that our Family Court Act that provides that every family court should first try for resolution of disputes by the court herself or himself. Family court should decide that, help the parties to resolve their issues. They have got even counselors attached to the family courts just to see that parties resolve their issues. It's not that they should always separate. It is not they should always get together. Only they decide themselves with the help of the counselor or the family court judge. And particularly there is a judgment which I want to refer to, and that is K. Srinivas Rao versus D.A. Deepa SC 2176, where Justice Ranjana Desai said that in every matrimonial discord and dispute, when counselors also are not successful, mediation must be tried because mediators are trained with negotiation skills and communication techniques. They help the parties to resolve their issues. And that is why we can see there are so many matters where parties are approaching for pre-litigation mediation also at this stage for resolution of their disputes. Now, a further vacuum was created because sometimes the parties agreed and entered into a settlement agreement, but ultimately the settlement agreement was not given a final shape because of some issues or the other. And one of them was that the parties withdraw their consent or do not continue with their consent for seeking divorce. In that situation, what was to be done? There were certain judgments which said that party should be held for contempt of court, but other judgments said that in this situation, the party had a statutory right. How can party be forced to continue to give consent for divorce, whereas statute provides that parties can rethink about their relationship? In that situation, another judgment helped us, and that is also in Delhi. I will just say, tell you that is 2018-249 DLT 289. Justice Hima Kohli was heading the bench at that point of time. And in that situation, that matter, that judgment guides us how to write mediation settlements. It should be clear, unambiguous. It should be stated in such a way so that parties do not resign, stipulate, undertaking of the parties, and then provide even penalties or fines so that parties generally do not default, but at the same time not compromising with the statutory right. So what the court has ultimately said, that in that situation, if a party is resigning from his or her previously given consent, then the party who is not in default should be brought in that status quo ante position, in the sense wherever the party was before the settlement. So these two judgments really help us to take care of certain things which are very, very important and integral to the mediation settlements.
Well, thank you, ma'am. Ma'am, from this, I would like to know that the advent of Section 12A in the Commercial Courts Act have made mediation from an alternate dispute resolution to an apt dispute resolution. Ma'am, can you enlighten us on the same?
Yes, Palak, we all know in 2015 Commercial Courts Act was introduced, and maybe for the reason because at the global level there was a lot of progress, there was a lot of growth at commercial level, and this act was brought into existence. In 2018, it was thought appropriate to introduce mediation in this, and Section 12A was introduced. That is a Bible in itself for this particular act. And under this act, we call it pre-institution mediation, and it has to be filed with the authority, and authority under the act is Delhi State Legal Services Authority. And because the Delhi State Legal Services Authorities did not have the infrastructure at that point of time, even now I think in most of the states it is not there, and then SOP was executed between the authority and particularly in our Delhi High Court, and all the matters which are fixed, which are appropriate for institution at pre-institution mediation stage, they are filed with the authority, and parties are being forwarded to the court annexed mediation center of that particular jurisdiction. As in Delhi High Court, we are getting those matters which are of the jurisdiction of the High Court, and we are in a position to help the parties to resolve their disputes, because act provides that. And particularly under this act, the benefit is under this act also the mediation agreement is a award in itself, and for that you don't have to go anywhere else under this act itself. And second benefit is that though the initial period is 3 months, even further 2 months period can be there with the consent of the parties, and the benefit is you get an extension even of the limitation period. So this is how it is being promoted everywhere, and people are taking benefit of this. Of course, in exceptionally urgent matters, people can go directly to court, but otherwise it is mandatorily required for everybody to come for mediation, but then it is voluntariness has not been taken away. People may or people may not resolve.
Right, ma'am. And as you mentioned about the Delhi High Court and Samadhan, I would like to know what caught the eye of Samadhan to adopt online dispute resolution.
Palak, for Delhi High Court Mediation and Conciliation Centre, known as Samadhan, that means resolution, this was not new to us, because in the year 2017 itself, our courts, our committee, overseeing committee, realized the necessity of having sophisticated technology to bridge the gap between the parties who were located at different locations like overseas or physically handicapped. People were not in a position to come for many reasons, because there is a cumbersome process of getting a pass made. So at that point of time, our overseeing committee provided us a very technically strong video conferencing facility with high quality audio and full motion video images. We were already holding these mediations sometimes online, where parties were not in a position to reach the center. Sometimes even both the parties were not present. So we were not new to this, but because of this pandemic, our committee, oversensitive committee, because now they wanted this mediation to be started online. Earlier, mediators were sitting in the center. Now even mediators are sitting at home. We have been provided this WebEx facility, and mediation has reached everybody's home. So what we were thinking at one point of time, that maybe we have to learn the technology for holding ODR. It was thrust upon us because of this pandemic, But I must tell you, and I want to acknowledge that all the mediators on our panel are very well equipped. They have been trained. They are being provided all facilities, and everybody, including lawyers, parties, and mediators, are sitting at their respective homes, and mediation is being conducted successfully.
To conclude our talk, ma'am, I would like to seize this opportunity, and rightly so on behalf of many young lawyers as well, to understand how to deal with the client who approaches us with a dispute, knowing that litigation takes time. What are the alternate options that we can explore?
Palak, in Delhi High Court particularly, if you see that court building is there, arbitration center is there, mediation center is there, and Delhi State Legal Services Office is also there. So we have a multi-door courtroom, and wherever you feel that this case is fit for mediation, arbitration, or litigation, you can take it. And so far as my role or your role as lawyer is, we are service providers. Clients reach us, they want justice today. They want what they need today, what they desire, they want it today. So it is for us to analyze at that point of time whether this matter is fit for mediation, conciliation, arbitration, or for Lok Adalat. And at that point of time, we have to decide if it is for mediation, like in our center, we have pre-litigation mediation, and I must appreciate, acknowledge the contribution of lawyers in our center. Generally, lawyers recommend their clients for pre-institution mediation, pre-litigation mediation, and they participate. So when you help to your clients to get justice today, nothing is taken away from you. Rather, it adds to you, to your name, to your fame, your work quality, because people recommend you for the reason that you get them results today. So that is how we can just in today's scenario, and today's scenario is not like that when you fight case for longer period without getting results to your client, the counsel's quality is appreciated. Today is the time when people need today, they should get it today.
Thank you so much, ma'am. We have been obliged with your presence and deep wisdom on this subject. And our audience can take this opportunity to pose their questions in the chat box, which will be taken at the end of today's session. I now invite Saurabroto Datta to take over the moderation from here. Over to you, Saurav. Sorry, you're on mute.
He needs to unmute.
Hello. Yes, am I audible now? I'm so sorry, there was some error. I thank you, Palak, and thank you, ma'am, for so wonderfully explaining this concept to us. With the benefits so rightly explained by ma'am, I would now like to move to the applications of these benefits on the micro, small, and medium enterprises, for which we have Mr. Somesh Arora. I welcome you, sir.
Thank you.
Sir, to begin with, I would like to ask you, how has mediation helped the micro, small, and medium enterprises in India?
Wonderful. Very interesting question. Thanks, Ms. Datta.
Yes.
This subject is very close to my heart. One of the most beautiful drafted legislatures. And when we read the act and understand the whole concept, let's first understand what is MSMEs basically. So MSMEs are basically micro, small, and medium enterprises. So any enterprise which is less than 1 crore of investment and less than 5 crore of turnover is called micro. It goes to 5 crore of investment and 50 crore of turnover for small, and 50 crore investment to 50 crores turnover is called medium. Now, having said that, there are few interesting things. Let's pick up and then we develop further. So I was just going through the data available on the web. In India, as of now, we have almost 90.19 lakh MSME and 6.33 crore, these are the registered ones. So 90 lakh odd MSMEs are registered, and we have about 6.33 crore MSMEs in India. So we can just find the kind of quantum of MSMEs in India and the mileage out of which 6.30 crore MSM are micro enterprises, rest are medium and small. They contribute 33% of India's GDP. So 1/3 of Indian GDP is by these MSMEs only. Out of which these MSMEs, 58,000 applications per year are registered normally with the Samadhan, the portal, towards mediation and settlement of disputes. And unfortunately, here we really look forward. Only 5,000 of these applications per se, I'm saying about last year data, only 5,000 of them were settled through mediation. So it's just the 10% of the applications lodged towards settlement. Now, if you try to understand the act per se, it's a beautiful drafted act. It is something which is not otherwise. If you see, you need to prove your claims and other things. But when you see this act, the obligation is upon the buyer to pay. And if you don't pay on time, there are implications and repercussions, which is all settled. So the supplier has to only prove that he has supplied either the product or the services and raised an invoice. And if you don't pay within the stipulated time, you are bound to pay the triple the interest and other things. We'll discuss later on this. So in this given circumstances, still it's only 10% of the lodged applications which are basically compromised. It looks like that yes, the scope is too big. People are still not able to trust it. With 6.30 crores of micro enterprises, so many disputes of invoice defaults and payment defaults, and they're all more lodged on other platforms, maybe commercial courts or maybe IBCs. People are not coming to councils per se. So the act is drafted very nicely, but unfortunately, as of now, we are not finding these kind of reliefs or maybe the mediation processes carried by the councils. There are about 60 councils in this country to be really effectuating the thought process which was of the legislature. So that is one place where we look forward. There is a lot of scope for institutions to come up and take over and try to go for settlement. The way Ma'am Veena Ralli was trying to say that high courts and the courts are proactive. I think so. The councils still need to be active, if not proactive, to this stage. Correct?
Yes, sir. So like you said, like only 10% of the lodged cases have been only compromised as of now. Do you feel that there is a furtheration of a legislation, or there should be something more, sir, to push the settlement of the disputes with respect to these micro, small, medium enterprises?
Oh, interesting. So when it comes to the act, okay, let's spend 2 minutes to understand the act. Normally, the audience per se are either lawyers or law graduates. So I was just trying to read and work on it, and just 4 sections, and I think so. You don't require code for all this. For the reason because how the flow of the act is. Normally, when a supplier supplies the goods or the services to the buyer, there's an appointed date. What is that date like? It is the actual delivery of the goods or rendering of services. Part 1. Now, in case there is non-satisfaction by the buyer on either the goods or the services, he or she or the company must lodge. I'm using the word must lodge in writing. So must and in writing, they're two very important words. Objection to the buyer about non-providing of services or products. So the obligation is on the buyer and not the supplier. The supplier has supplied, and the day it is supplied, the date is clear. That's called appointed date. Now suppose it is not objected to by the supplier. Then what happens? It is deemed acceptance. So the onus is exactly on the buyer to either lodge the objection, that too in writing, or otherwise it's a deemed acceptance. So the entire idea of the act is that the moment goods are supplied, services provided, thank you very much, the supplier is entitled to have the payment. This is one part. The second part is section 15. What is the liability of the buyer? The buyer is required to pay the amount, correct, on the agreed date. So the buyer and the supplier may have some particular date as an agreed date. So they need to, the supplier is required to pay the amount, the buyer is required to pay the amount. And suppose there is no agreed date, then before the appointed date, so within 15 days, you have to pay the amount. 45 days, you have to pay the amount. And in any case, you cannot exceed more than 45 days. So even if you have agreed, the parties have signed a document saying that we will pay after 6 months, you cannot do that. So this act is prevailing upon even your written contract also. So the buyer has to only prove that yes, it invoice, supply the goods and raise the invoice. Rest entire thing goes on the buyer. Now suppose the buyer fails to pay, then what are the consequences? The consequences are that you are required to pay 3 times of the bank rate notified by RBI. Suppose the bank rate right now is 4.25. So about 14% or 13% rate of interest you need to pay. Very interesting, the court says, the law says that in spite of any agreement contrary. So the court is not concerned, the law is not concerned about the contract, about your agreement, or any law contrary to it. So it prevails upon everything. And this buyer is supposed to pay what? The amount and the interest paid. So this is the act. As a supplier, I am required only to supply the goods and raise the invoice, and nothing more than that. So if this is so, now if the moment you say legislation, now this is the best piece they can draft. Let's go further. Section 18 says that in case the payment is not made to the supplier, he will go to the council and he will lodge a claim before the council, and the council will refer this matter to itself for conciliation, or they may refer it to any institution or center for conciliation. In case this conciliation fails, then this council will act as an arbitrator also. Normally, the world over, the law is that either you act as a mediator or you act as an arbitrator. Here you can act in both, so you can wear both the hats. In the conciliation, you can have certain exchanges which might be confidential, but then you act as an arbitrator, so you know all the gray areas also about the parties. Then it goes to the extent that they can refer this dispute to the any other institution or the center also. So they can do that also. They can wear the hat of arbitrator and start the arbitration. Now this arbitration, whatever is answered, if it is answered in favor of the supplier, the only test is, did you supply? Invoice is there, perfect, wonderful. Rest the onus is on the buyer. So buyer has to prove that no, he has not supplied. So did you object? No, I did not object. So it's deemed against you. You cannot have better legislature than this, man. Then interestingly, suppose you challenge this award, you need to deposit 75% of the award amount. The award amount is normally what? The quantum, the principal amount, and the interest on it, which is about 13% odd. So 75% is deposited, and court may give an order to the extent that some amount may be paid to the supplier also meanwhile out of this. The next very interesting thing, which I have not seen in other acts, and why I want to refer this also, Mr. Datta, is that the buyer which is basically into annual account audits, they need to reflect 2 things. One, the principal amount payable to the suppliers and the interest accrued on this principal amount. So this is something you are admitting every time, that this is the amount still payable to one of the MSMEs, which is a supplier. So if I answer your question, I don't think so there's much to be added now. It's all answered more or less. And as the council, you are just required to see the documents to the extent of invoice, agreement in writing or not, and thank you very much. Rest all is upon the supplier. And if you don't produce your documents of objection, it is deemed against you. So I think so the legislature is beautifully drafted, and we may not think of adding certain more things onto this. We can go ahead with this legislature. It's only the willpower and the activism which we look forward from the councils to take it up further and develop. I hope I have answered your this question.
Yes, sir. To this respect, sir, I would like to ask, like, there is a new concept that has been introduced, that is MSME Samadhan. So now for the introduction of MSME Samadhan in cases of online dispute resolution, how has it helped out, or rather how it has helped in the sector of MSME, sir?
So the way I gave you the figure,
Yes.
58,000 applications were lodged. These are all government figures on the
Yes, sir.
website of Samadhan. 58,000 applications were lodged, out of which only 5,000 were compromised, mutual consent.
Yes.
So only 10% is the result.
Yes.
The second question which might come from you is why only 10%, why not 90%?
Yes.
If it goes to can I request others to just go for on mute, please? So now, Mr. Datta, in case you ask me this question per se, that why only 10% and what about 90%? So if we go to Delhi High Court Mediation Centre or proactive lawyers who are working on mediation like Mrs. Ralli, they are someone who are working on it with a very clear thought process, that end of the day the whole thought process is that let's make best efforts for the mediation, and that's why they're able to give a lot of time to this. Unfortunately, with the council, they are not able to give that kind of timeline, because the parties do want some time to settle their respective concerns, certain egos, certain difficulties, harassments and all that they have suffered. So they want to share all this. So mediation, the way I understand, is it is more of first developing a little rapport and then developing a trust. Then parties open up and then they say, okay, we are ready for mediation. So it takes about 2-3 hearings to first understand the parties and develop. Unfortunately, with council, they straight away come to the topic. Okay, if amount is payable, not payable, are you paying, not paying? Thank you very much. We send for arbitration. So Samadhan is a wonderful platform, but the willpower is not there. And though the act clearly says that institutions like WebNai and others can be referred all this, but I don't think so that they are referring right now. Maybe in times to come, they understand that yes, if it is given a private participation, it will look far better, because the council members are not mediators, they are not trained mediators, they are more of government officials or an industry player or a banker who do not spend much time on mediation. So if it is done, I think so that could be a far better effort for settlement of disputes.
Like you said, sir, like you have given me the statistics, only 10% of it has been compromised. And rather, what you have observed is that the parties do want some time. They do want some time to maybe open up to the mediators and then go forward with their problems. What do you like to say, sir, on a personal viewpoint as to how to promote the process of mediation amongst the micro and medium sectors and the small sector enterprises, sir?
Lovely. So during all this, whenever we were doing all this litigation, so the first effort is conciliation. And what I'm saying about the council, that's my personal experience. The kind of time which is really required. So definitely councillors started working on ODR and they are trying to be on the online dispute resolutions, but they're not trained on this. They're not acting as professionals. So first and foremost thing is that maybe the government may look into and give some kind of training to them on this mediation aspect, because people want to pay. Supplier knows it very well that yes, he is required to pay, not today, but end of the day sometime. In case they are insolvent, that is different. Otherwise, and the liability is recurring and increasing. With 13% rate of interest, you need to pay. And the possibilities, if you are not objected to, you don't have any defense also. So you know the heart of heart. So somebody who is coming up and telling that yes, at this stage, on the mediation stage itself, it's better to clear off on certain better figures on the quantum which the buyer and supplier may look forward at that stage, because at the initial stage Buyer wants the money, doesn't want to wait for 2-3 years, and the supplier also knows that the liability is increasing. So that's one aspect of it where they can really work on and caution them. So in fact, the supplier doesn't understand much about the law. He's more into the hands of his lawyers who say, "Don't worry, we'll handle it." But unfortunately, this country still don't have MSME expert lawyers. So they still treat that this act is more of like any other civil dispute, where the liability is to be, in fact, proved by the supplier, whereas the act is totally drafted totally differently. The liability is upon the buyer, and he needs to prove that why he has not objected to, and the grounds are very, very limited. So that's one. Two, I'll share you a couple of cases. In fact, interesting cases. In one of the cases, we lodged a claim in Hyderabad Council. Now, this was a case where, interestingly, our client provided certain consultancy services, ensuring that in case we are able to get this unit operational on a profitable basis, we will take 20% of whatever profits you earn because of our efforts. So it was more of a consultancy firm. They worked for 1 year, and the profits went to the extent of 14 crores because of their efforts. So this company lodged a claim to the client, the buyer, that you need to pay about 200 crores and 40 lakh rupees toward our services charges. Now, this supplier was shocked. He said, 2 crores 40 lakhs. That's huge amounts. Let's compromise on 30 lakhs. The contract is clear. You are not objecting to the invoice. You're just trying to negotiate because you're not ready. When we go to the council, again, the council is also shocked. Oh my God. For this 1 year services, you are charging 2 crore 40 lakhs, and that too during COVID period and other things and all that. Now they are not appreciating the practical efforts done by the consultancy firm. They are providing services. The councils are not understanding that it is not only the product, services are equally important. And these services have ultimately turned the operations of the company and the profits to about 14 crores odd, and that 20% was the agreement. So if it would have gone to a mediation center where you have practical people who understands this and understands the agreement, the contracts are very clearly drafted. So per se, I personally feel that these kind of things, if they go to the private players who understands these, they'll be able to guide supplier that if there's a contract like that, if you're paying 240, ultimately you're also getting a profit of good about 9.5 crore rupees, which is only because of their efforts. They have given so much time and energy to this project. Another very interesting case, I think so I have a minute or more.
Yes, sure.
Which we have filed at the first unique case, where our client, which is into charter services of the helicopters. So these helicopters were given to one of the Haryana elections, and one of the Congress leaders sat in that, and he says there is no AC in the helicopter and all that. So we went to MSME saying that the helicopter was provided to you, have enjoyed the services. Now AC or cooler or whatever, that is separate. You have not lodged an objection to this. You have enjoyed the facilities. Now at the time of payment, you are not paying us. So it was so difficult for the council to understand that these kind of payment claims also fall within the MSME council. So it took us a little time to make them understand. So these are something which is not recognized by the councils right now, but they are all in the industry. So we are trying different tricks to make the council now more acquainted with the act and their powers. So hopefully things will change. And with ODR, basically, because you have more now time to explain them, the crowd is not there, and you are able to speak to them one-on-one for some time. Looks like that with the time they'll gain. And if they can reach to people like you, Webnai and others, I think so. MSMEs with 6.3 crore MSMEs, the disputes will be really pushed better, and the country will grow with less disputes and more recoveries for MSMEs. I think so. I've answered your this query.
Yes, sir. Thank you so much, sir. We are truly very clear now on this subject issue, and us and both the audience, I believe so. Now, I have Mr. AJ Jawad, who is the master of this game, who himself is a mediation trainer and an advocate. with all due respect, sir, I would like to ask you, like, what has been, like, we all have been discussing on this point that there has to be an online dispute resolution, as in the need of mediation, the need of ODR at this point of time. As we all know, the relevancy of the amendments also with respect to Consumer Protection Act, sir, as per say mediation and ODR. What is your take, sir, on this part?
Thank you, Saurabh, and Webnyai, first of all, for this opportunity to be on such an illustrious panel. I feel truly honored, especially after hearing both Veena ma'am and Mr. Somesh. It has been quite an enlightening experience for me. Coming to your question, Saurabh, see, the new act is I would call it as a very radically progressive piece of legislation in terms of, advancing the rights of consumers. Some of the significant provisions of the new act we need to look into to understand, where we stand on this. Because apart from the pecuniary enhancement of the jurisdiction, it covers e-commerce transactions. It provides for e-filing of consumer complaints. It establishes Central Consumer Protection Authority, or the CCPA, which is headed by a Director General who has wide powers of inquiry, investigation, and enforcement of consumer law violations.
Yes.
It has also introduced the concept of what is called as product liability. So what it does is it brings in its scope the product manufacturer, the product service provider, and the product seller for any claim for compensation. So this what this means is that the e-commerce platforms are also liable, and they cannot, the defense that they are merely acting as aggregators or online platforms will no longer hold any water. Product manufacturers will be liable in a product liability action. So even if the manufacturer proves that he was not negligent in making the product, or he did not indulge in any fraudulent misrepresentation in making an express product warranty. Now, the CCPA has also been empowered to take action against misleading advertisements. The CCPA has the power to impose penalties up to 10 lakhs for any false or misleading advertisements, and also imprisonment up to 2 years. Repeat offense may attract a penalty of up to rupees 50 lakhs and 5 years imprisonment. And the CCPA has further been granted very wide powers to take suo motu actions, recall products, order reimbursement of the price of goods or services, cancel licenses, file class action suits if supposing a consumer complaint affects more than one individual. So now one of the very significant aspects of the new act is that it also casts an onus on the endorsers of a product. In other words, the celebrities, whether it is an Amir Khan or a Virat Kohli or whoever it might be, if they are promoting a product, they are expected to do their own due diligence and verify the veracity of the claims that are made regarding the product quality and efficacy in the advertisements in which they appear and endorse the products. So unfair trade practices like, for example, sharing personal information of the customer, which is given in confidence, are prohibited under the new act, and that also attracts penalties if there's a violation of that confidentiality. Now, the most important change which is brought about under the new act, which is relevant for the context of our today's webinar, is the provision for the use of mediation for consumer dispute resolution. There is a chapter 5, which sections 74 to 81, which deal with mediation. Now, the new act mandates the state and central governments to establish consumer mediation cells in the district, state, and national consumer disputes redressal commissions. And it further provides that each of these cells should have a panel of mediators attached to it. Now, it is progressive in the sense that it recognizes the technological advancements that have been made so far. And unlike the old act, it provides for e-filing of the complaints. So anybody sitting anywhere can file the complaint. What is more important and significant is that, contrary to the conventional manner of determining jurisdiction, normally it used to be where the respondent would be residing or carrying on business, or where the cause of action arises. Under the new act, the e-filing of the complaint can be done before the jurisdictional consumer forum where the consumer resides or works. So it also provides for hearing or examining of parties via video conferencing. So from that, what naturally flows out is that automatically, of course, when we talk about doing mediations in disputes that are referred to by the under the new act for mediation, the use of ADR also is entirely possible there. So when you are talking about hearing and examination of parties and witnesses via video conferencing, by necessary implication, there is a scope for even conducting the mediations online. So ODR has immense scope under the new act is what my opinion is from a reading of the act. Okay.
Yes, sir. So, like we all have discussed now that the need of mediation is utmost considering today's situation. So, you being a trainer yourself, what do you feel are the techniques that are used to train a mediator dealing with consumer disputes? And what is the entire process of this transformation of the training session that takes place, sir?
That's a good question, Saurabh. Now, first of all, before I go into that, I would like to point out that most of our legislations, like even for example, the Companies Act, even our, the rules framed by our high courts for mediations. One of the most serious lacuna which I find is that the qualifications that are prescribed for empanelment as a mediator. Okay. Now, for example, if you take this, the rules framed under the new act. Okay, we have the National Consumer Disputes and Redressal Commission regulations that have come out now. They have issued a notification under section 103 of the new act. Now, it provides for the, being the qualifications that are being prescribed. One, retired judges of Supreme Court of India. Two, retired judges of high courts. Three, retired members of a consumer commission. Four, retired district and sessions judges, retired additional district and sessions judges, or other retired members of the higher judicial service. Retired judicial officers having experience of not less than 10 years. Advocates with the minimum of 10 years of experience at the bar. Mediators empaneled with the mediation cell of the Supreme Court of India, High Court, or a district court. That is understandable because they are already trained. A person having experience of at least 5 years in mediation or conciliation, okay, the assumption there is he's a person who is trained at least through experience. Experts or other professionals with at least 15 years experience, or retired senior bureaucrats or retired executives. Now, if you see the problem here, except where it says that, mediators empaneled with the mediation cell or persons having, experience of 5 years, the mediators, there's nothing contemplated about training as such. Now, this is the problem in other legislations also. So what is this training we are talking about? As I said, this regulation is very similar to the companies court rules as well as the mediation rules framed by the high courts. Now, this clearly shows that in India, the rule makers and the legislature have absolutely no idea about how the mediation process works. I'm being very blunt here. Apologies for that. But I think I have to tell you what exactly is the situation now. Now, mediation, is a very scientifically designed process where the mediator is trained to use specialized communication and negotiation skills to guide the parties through different stages through which the information is gathered, issues are identified, negotiation is facilitated, and agreement is reached. Mr. Somesh also pointed out this lacuna with reference to the MSME Act, because if you go to the council, do they have trained mediators? And that is what he was pointing out, that unless you have trained mediators, people who don't know how to conduct a mediation, because mediation is not just calling two parties, making them sit there and say, what is your problem? Oh, how much do you owe? Can we discuss how much you are willing to pay? It doesn't operate that way. There's a lot of trust and rapport building that happens, which Mr. Somesh also pointed out. Okay. So now undoubtedly, all the people, other people mentioned in the regulation are eminently qualified in the respective domains, undoubtedly. But the question is, can a judge be a mediator just by virtue of having retired as a judge? What is he going to do as a mediator if he's not going to be trained in the nuances of mediation? He's going to judge, he's not going to mediate. So also advocates. Now, advocates are trained in an adversarial process and are better equipped in arguing cases for the clients. So we tell advocates who get trained as mediators, when we are training advocates as mediators, we tell them that what needs to be done is you have to do a lot of unlearning. Because in mediation, we don't have a fault finding or a blame gaming that is happening. So mediation is simply not a zero-sum game. But fortunately, under the consumer protection, the rules which I have referred to, framed by the National Commission, apparently somebody who understands mediation was sitting over there while drafting the rules. And in Regulation 9, there is a provision that those who are empaneled as mediators shall be given appropriate training in conducting mediation by such experts as may be nominated by the mediation cell. And it shall also be obligatory for them to attend such training. So what is very encouraging and what I'm really happy to see about is that the regulations provide for a mandatory training for those persons empaneled as mediators in the consumer mediation cells. Now, the transformation that you spoke about, the transformation that mediation training can possibly bring about in a person is to, it operates on different levels. Okay, first of all, to look at a problem as being distinct from the people who are involved. Normally, we identify the people with the problem. Okay. So the second thing would be to understand the need for a collaborative approach to problem solving. See, as lawyers, what are we trained? We are trained as gladiators. We go to the court, we fight a case for the client. The only difference is that in the ancient Roman arenas, the gladiators used to die. But here the clients die. So we go and fight, we do the fighting, but the clients die if we lose or even if we win. So the other thing is to look beyond the stated positions. See what normally, in any, if supposing a person is not trained in negotiation and mediation, the approach would not be to look at what are the underlying issues, what are the common interests of the parties, but to straight away jump into negotiating on the positions of the parties, about the demands that they're making. So you straight away go into sort of positional bargaining that happens without understanding what their real interests and needs are. So it's very important that you need to look beyond the stated positions of the parties to not only you understand, but also help them to understand what their real interests and needs are, and to encourage them to work with each other in evolving, multiple solutions to a problem. So that is what Mr. Somesh was saying also, that when you develop the trust and rapport, and you look beyond the expressed positions of the parties and see how the problem can be resolved. Okay. So basically, you need to bring about the transformation through this mediation training so that mediators don't have a very aggressive approach, but they have a more collaborative approach. And most important, how to achieve all these things without really advising the parties or arguing with them or judging them based on their positions. So that is the transformation that we are talking about when it comes to mediation training.
So with this point of view, we would like to move to our last round of set of questions. This is a rapid round of questions, and you are expected to answer this in terms of the online dispute resolution that takes place. That it can be a small bit of problems and a solution coming from your side.
Are you going to give me some like coffee with Karan? Am I going to get some?
Okay. No, sir. Yes. And I would request our audience also, if they have any questions that they want to ask with our honorable panelists, they can always post that on our meeting chat. So moving on with these questions, the first problem that I would like to put forward is the reach of technology in rural India, sir, with respect to online dispute resolution, sir.
See, technology is a bit of a challenge, undoubtedly, because in rural India, we don't have the kind of internet connectivity or, the requisite bandwidth, the kind of devices and other infrastructure that you may really require to do this. Now, the problem is that, are we going to say that since that is not available, let us not do it? Now, if we are not doing it, are they getting access to justice? Let us look at it from the perspective of access to justice. Are they can they really afford to travel to their district headquarters, engage a lawyer, file a complaint, assuming there is no technology, there is no e-filing, There is no video conferencing. Let's forget about that. If they are not, are they going to be able to agitate their rights and get justice if this is not available? So the answer, in my view, would be to say that yes, these are the handicaps, these are the challenges. We need to provide that technology to them. Now we are all used to, for example, cyber cafes. We are used to ATMs now. Every village has got an ATM. So what needs to be done is, if you really want to effectively implement these legislations, make them really work for the people and provide them access to justice, the option is we need to explore those possibilities. Can we set up something like cyber cafes where people like senior citizens who are not so tech savvy, can they be guided by people who are there, who staff those centers? Can they guide them towards filing of these complaints? Yes. Can they help them in conducting these proceedings? So we need to have trained people, not many, 2 or 3 people in each center may do that. You're creating employment for qualified youth by doing that. You're providing them an opportunity, and you're also providing access to justice. You're using the technology to help people to access justice. So that is my personal.
With respect to this only, sir, I wanted to move on to this question, like what will be the understanding of digital filing and ODR with respect to the senior citizens? Should there be some sort of webinars, maybe like what we are conducting? Should there be some sort of camps just to inform these people about the technology?
I think camps may be more in order, Saurabh.
Yes.
See, we are not saying that senior citizens will not be able to access this. You may be right, because we are now living in a smartphone era. Okay, we are now living in an era of e-commerce. Okay, sometimes I get the feeling the number of products that we keep getting from Amazon into my house, I feel that Jeff Bezos is getting rich at my cost. Okay, so it becomes so easy. Yes. Click of a button, you buy anything. And that is being done even by the senior citizens. Okay. Of course, talking about rural areas, yes, people who are not so tech savvy, who are not used to it, maybe, some kind of, we can organize awareness campaigns and provide them with somebody who can assist them in accessing this. Yes, sir.
Yes, sir. So, sir, as we spoke about the facilities like providing camps, do you feel like what is the scenario of infrastructure and ODR facilities in our courtroom today?
See, in our courtroom, there are challenges. Okay. Now, I recently read it's actually, you can take it as a joke, but what happened actually was in the Supreme Court. One of the lawyers lost connectivity, so the learned judges told the court officer to contact him on the phone. Yes. So when he came up on the phone, one of the judges took the phone and started asking him a lot of questions about the case. So the lawyer finally told that, वो सब तो ठीक है, आप इतने सवाल पूछ रहे हैं हमसे, पहले तो ये बताइए आप कौन हैं, आप हैं कौन? So this really happened in the Supreme Court. Okay, now the problem is, technology is a little bit of an issue, because, for example, if you take my own case, yes, I live outside the city limit. And for the past many years, I have been struggling to get a proper optic fiber connection, because internet was, I had to depend on hotspots and on dongles. So I was having a lot of trouble. Now, finally, only last week, I got a fiber optic connection. So the solution is to bring the technology, spread the technology so that it has a wider reach. Okay, like how we are laying roads, we are providing toilets, we are providing other facilities to people. We need to also provide them with the technology. And once you provide them with the technology, it's a question of people getting used to it, because nowadays technology is so simplified that it is only, all you need to do is just follow some steps and you will get to learn. So probably with some amount of training, people may start learning it. And nowadays, see, for example, if you don't mind me taking just a few more minutes, 2 or 3 minutes more, we conducted a training program for mediators, how to conduct online mediations. Now, many of the mediators who came for this training, because they were sitting in their homes, and we were conducting the program online. the training online. And one of the mediators, I saw one small hand coming up and typing things and, disappearing again, and one small head popping up. So I finally asked this gentleman, I said, who's there with you? And he said, sir, my grandson is sitting here with me because I don't know how to use these things and he's helping me to do this.
Yes.
Okay, so the reality is there are families. I'm talking about a mediator in a district. Okay.
Yes, sir.
Even in the cities, we have this problem where mediators are helped by their own children on how to operate the technology. So that learning process will happen. But the answer is, just because it is not there, we don't have technology, we don't have people, and the elderly cannot access it, or people in the mofussil areas cannot learn how to do it. That cannot be an answer, is what I'm saying. We need to embrace the reality that today we are living in an age of digitalization, and we have to embrace it, and we have to accept the fact that this is the future. So the question is how we take it forward. So that is my humble view about this matter.
So with this, I would like to move to our last question directed to you, sir. This is how to ensure privacy of parties and documents in prospect of online mediation. And I'd also like to mention Mr. Amitabh Singh, who is one of our audience. His question is also somewhat related. In your opinion, should data from mediation be stored in India, or will it be a problem? Little connected question, sir.
See, now here we have to, understand the fact that mediation being a voluntary process,
yes, sir.
There is a possibility that there may or may not be a settlement between the parties. There is a possibility that any data that is collected by one party against the other party may be used by that party against the other party. That possibility is there. We may be compromising the position of a party because of the breach of confidentiality. Now, the thing is, for that, we have to see how we can evolve those rules of confidentiality to protect the data online. And we also need to take precautions. Like, for example, in mediation, there's a provision for having private sessions with the parties. So a mediator can always explain to the parties that, look, if there is any confidential information that you would like to share with me, you can always do it in a private session so that the other side does not get to know as to what is the particular document or particular information that the party is sharing with the mediator. The other party need not know about that unless it is absolutely necessary and the parties consent to waive the confidentiality. The mediator will be bound by the confidentiality to keep the entire information or document or whatever things he gets through the mediation process confidential. And we also have to, one more thing we can possibly consider is get the parties to sign an agreement of confidentiality before starting the mediation.
Yes.
So that any breach of that confidentiality can always be held against them. The third thing, what I feel is, I think there needs to be, the legislature seriously needs to consider enacting, incorporating provisions where in a mediation, if one of the parties breaches the confidentiality, number one, the court will not look into the evidence that is gathered through the mediation process. Number two, there is some element of penalty that is imposed on a party who tries to use this confidential information. So I think 2 or 3 of these steps may help us to protect the confidentiality and make sure that parties' interests are not compromised, because the mediation process is based on trust.
Yes, sir.
Okay, and it is an informal process where a lot of it's not just what the parties have, but also how they feel about it. So a lot of things may come about in mediation, a lot of information may be exchanged. So it is very important that confidentiality needs to be protected. Yes. So I think certain steps, proactive steps in that direction, So one is the agreement to mediate. Number 2 is informing the parties that they can exchange the confidential information in a private session with the mediator. Number 3, an appropriate provision of law, which says that this information cannot be used, and if it is used, it will be visited with penalties. So these kind of steps would help us to, ensure that the confidentiality is sacrosanct in a mediation process.
Yes, sir. So with this respect, I would like to now move on to the questions which has been posted by the audience. I see a very common question that has been asked by a number of audience, so I'll post it for all our speakers and panelists today. That is how finally the students can be promoted towards mediation and other forms of dispute resolution? That has been posted as a common question. So, ma'am, Somesh sir, anyone that, if any one of you would like to take that.
If I may say something, ma'am, Veena ma'am, would you mind if I just, I think that that question was also dealt with by her
Yes.
in her session. But just to add on to what she said, see, my feeling, my opinion is that the very format of our legal education needs to be changed completely. Because I think that is happening because Bar Council of India has issued a circular now making mediation training, teaching of mediation mandatory in all law schools. Okay, that's a very positive, proactive step in that direction. But what we need to do basically is that we need to change the mindset of lawyers when they come out of the law school. And that is happening. I'm seeing it happening because I do a lot of training in universities and colleges. So that mindset needs to be changed, that you are not a gladiator. Okay, you're not there to simply treat a case as, because there's, as the saying goes, if the only tool you have is the hammer, every problem looks like a nail. So you don't have to necessarily treat every problem as a nail. This is the only one size fits all kind of method. Veena ma'am also referred to the multi-door courthouse concept. Okay, if a matter comes to the court, it is not necessary, it should lead to trial and it should lead to an adjudication. There should be other avenues open for the parties. They can opt for arbitration, they can opt for neutral evaluation, they can opt for a judicial settlement, they can opt to go for a lok adalat, they can opt for mediation, they can opt for conciliation. There are so many avenues that are open. But what needs to change basically is, instead of the adversarial mindset that is cultivated in the very way our legal education is structured, change that adversarial mindset to a collaborative mindset. Lawyers not as problem aggravators, but as problem solvers. So there I see, there I feel, unless that mindset change happens, unless you treat the client as a person having a problem that needs to be resolved, okay, not that the problem should be complicated and the problem should be aggravated or it has to necessarily go to court. So when lawyers start addressing, looking at their clients and their clients' problems from that perspective, that would be a major change that can really happen, which will promote a more collaborative way of conflict resolution, and that would be in the longer run, in the larger interest of society and community. I feel that would be the best way to deal with the issue. I welcome my other colleagues to share their views on that.
Okay, Mr. Datta, I'll add on here.
Yes,
Very interesting thing.
yes.
So what we did in our office, Sapphire and Sage, we started a program called Train and Engage, where we started something called mediation for interns, so law students. I don't trust lawyers to be good mediators. My apologies for that, except Mr. Jawad and Ms. Personally, if you ask me, I'm not a good mediator. I am more of a gladiator who wants to fight it out all blast. But then we tried this trick for certain of our clients who had small issues, 30, 40, 50,000 rupees recoveries from other court traders or other things. So we started a mediation cell amongst ourselves. All these law interns, they came, and believe me, a little persuasion by them, calling the other client, and little bit of effort. I think so. Almost 7 cases have been resolved in last 3 months.
Wow.
So this is something which is very, very workable, because these are law students who want to work on it. So I just want to add that. And if you have people who really want to learn mediation, not as a trainee, but they want to make an effort, refer to us, we'll help them out. Thank you very much.
Sure, sir.
In fact, just to add one thing, Maharashtra National Law University has introduced an MA in mediation, a master's degree in mediation, which is a 2-year course. So it's exclusively on mediation.
Okay.
So the change, we are seeing the change happening actually.
Coming to you, ma'am. Ma'am, your mic has been muted, I believe.
Just to add to what my other panelists have already said,
Yes.
rightly said that many training programs are already taking in universities, and I want to put on record that UPES Dehradun University is conducting annually 1 credit course since 2009 for all the students. And they have options for many subjects like arbitration, mediation, and client counseling, and most of the students go for mediation because they find it the training process. I mean, Jawad will agree with me The training process in itself is so interesting that most of the students opt for this. Not only that, in university, even many awareness programs and otherwise also certain training programs are being conducted in other universities as well. And one more thing I want to tell you, that in our center, there is a scope for internship in the center. So many participants we are finding them, they apply, they are given time slots for the internship. And the only thing which we need to learn, as because we have seen only one type of justice dispersal redressal system, that is litigation. We have to show them that there can be justice to the parties, to the disputants, even through mediation or other alternative dispute resolution processes. We have to tell them that advocacy for litigation is different and advocacy for mediation is different. They need to understand, because as certain, Somesh ji was saying that certain timings we find lawyers being the biggest hurdle or impasse for the settlement. So if they know that my role as as lawyer in mediation, if we understand that, I think most of the problems get over. So we generally say that only all those matters get resolved where lawyers participate constructively, and all those matters do not settle where lawyers themselves become the roadblock. So we have to change the mindset. We have to tell them that all those people who get training need not be the mediators, but they can be good counsel for mediation, and they can get the results, good results to their clients today, what they need in present. And Saurabh, I would like to add one thing more, because in the previous question, Jawad was answering that so far as confidentiality on technology is concerned, we were also very conscious of this aspect in our center. And we have created one undertaking, before entering the web meeting room, all the participants, including the mediator, because the process doesn't permit us to separate it for the mediator, they have to first accept that undertaking, that I will maintain all type of confidentiality, all information written or oral discussed in the process of mediation or brought to my notice, and in case I use, I will be liable for certain things. So those penalties have also been mentioned. So that first pops up. Once it is accepted, only then the person can enter the web meeting room.
Okay. I believe the audience must be having. I believe, ma'am, that is the end of our session today. There has been no more questions from the audience, but whatever has been asked, I believe the audience is satisfied with the answers, and now they have a better insight about the concept of mediation with respect to micro, small, medium enterprises, as well as with respect to the Consumer Protection Act. Moving on with this, sir, now I would like to invite Advocate Nitin Kumar, who is a legal expert and has a prolific practice in the Punjab and Haryana High Court and the subordinate courts as well. He has been dealing with numerous cases relating to banks, financial institutions, companies. Union of India has been representing Union of India and state governments, and also has been a resident counsel for Messrs. Hindustan Lever Limited, Brookbin Bond Lipton India, and Itcher Tractors Limited. I welcome you, sir. I would like to have you on the virtual stage now, sir, to extend our vote of thanks. Over to you, sir.
Thank you, Subroto.
Thank you, sir.
On behalf of Team WebNay and on my own behalf as legal advisor of WebNay, I extend a very ardent vote of thanks to Madam Veena Ralli, Senior Mediator Secretary Samadhan DHC, Mr. Somesh Arora, Advocate and founder of Legally Alley and Sapphire and Sage, and Mr. AJ Jawad, a mediation trainer and advocate, for sparing their valuable time and sharing with us their experiences, findings, and opinions on resolving MSME and consumer disputes through online mediation. Through this user-friendly portal, we aim to make disputes resolutions more economical, less time-consuming, and hugely effective. Your deep insight into the field of mediation will positively help us in furtherance of our avowed objects. We urge you to book a live demo with WebNay and see our revolutionary platform for online dispute resolution. I must also appreciate all the participants for their interest, knowledgeable comments, and pointed queries. Thank you, and a very good day to all of you.
Thank you very
Thank
much.
you, sir.
So thank you much.
Thank
Thank
you very
you for
much.
joining us. Thank you for joining us today. WebNyai will soon be back with another enlightening session on dispute resolution. Do sign up with us to resolve your disputes in a quick and efficient manner. Thank you.
Thank
Thank you
you.
very much.
Thank you
Bye-bye.
so much.
Thank you, everyone.
Thank you, Palak.